Okay, welcome. For those who are just coming in, we do have a couple of seats still open in the front. We have 2 seats in the back, and then we're going to close the doors. People can come in, but they're going to have to stand in the back. 2 seats in the front. This is my professor. Come on down and take a seat. Keep this way. Come on. There's 3 seats here, sir. And then there's 2 seats in the front. Come all the way down. And there's one. Okay, right there? Right there. Okay, and there's one more seat in front. And then for those of you who do not have a seat, for fire code purposes, you can stay, but there's 2 seats right there in the very back, right there. See that gentleman right there? There. There should be a seat here. Okay. All right, is there anybody sitting next to a seat that is open? Okay, there's right there. Okay, so those of you who are standing, I'm afraid we can maybe pull in some seats from the hallway, but we're gonna have to close the doors. Okay. And there are no other empty seats. Close the doors, and we can have, people have to stand in the back. Okay. And nobody has any umbrellas, packages. I feel like I'm Southwest on the seat. Okay, great. Actually, we have 1 seat over here, Sandy. Professor Friedman, come on down. We're going to embarrass you. Welcome. My name is Wendy Schiller. I'm a professor of political science, first and foremost. I am also the interim director of the Watson Institute and the director of the Taubman Center for American Politics and Policy. We are thrilled today to be presenting the Noah Krieger Class of 93 Memorial Lecture. The Noah Krieger Class of 93 Memorial Lecture was named for Noah Krieger, a Brown undergraduate who was interested in political science, public policy, and economics, who died shortly after graduating from Brown. This series, established by his parents, brings distinguished public servants to campus and has brought, among others, Representative Gabe Amos, Senator Chris Murphy, Senator Angus King of Maine, and Ambassador Samantha Power. And we're thrilled today to welcome the Krieger family. So we have Sanford Krieger, Carol Krieger, and Paul Krieger in the front. And we want to thank him so much for 32 years of generosity in funding this lecture. Thank you so much. And in the spirit of bipartisanship, we have some notable luminaries in the audience. We have former mayor of Cranston, Alan Fung, and his partner, Barbara Ann Fung, state senator and mayor of Cranston, respectively. And we have the mayor of Providence, Brett Smiley, and his husband, Jim Durentis. So we are bipartisan at Brown. Today we have the great honor of welcoming Justice Stephen Breyer, retired Associate Justice of the Supreme Court of the United States. Justice Breyer will share insights from his distinguished career and discuss the themes of constitutional interpretation and democracy explored in his recent book, Reading the Constitution, Why I Chose Pragmatism, Not Textualism. We will offer an opportunity for folks to buy the book after the talk is concluded and get it signed by Justice Breyer. This event offers a rare opportunity to hear from one of the most influential legal minds of our time, reflecting on the role of the judiciary, the evolving meaning of the Constitution, and its impact on contemporary governance. As a very special treat, we have our moderator, Justin Driver, class of 97 at Brown, proud public policy undergrad. Winner of the Krieger Prize for Best Senior Honors Thesis in Policy. who worked with Professor Ross Chait, recently retired, who's also with us today. So we're happy to welcome him. He is the Robert R. Slaughter Professor of Law at Yale Law School. No pressure to those of you graduating from Brown to try to replicate his success. He specializes on education law and the politics of integration and segregation in schools. And we are really looking forward to this conversation. The run of show will be about 40 minutes of Q&A, and then we'll open it up for the questions that were pre-submitted, and then we do have a hard stop at 5:30, and then you'll be available to buy books or just talk to Justice Breyer, and we welcome you to Brown.
Okay. Thanks so much, Professor Schiller, for those warm introductions. Really delighted and honored to be with you all today. And I'm delighted that Justice Breyer is here today, and not only because I spent 1 year working in his chambers. I learned a lot during that year, but Justice...
So did I.
So let me just try to level set a little bit here and tell you what Justice Breyer has been up to over the last 20 years. He has been attempting to articulate his judicial vision, and as the book that he is here to talk about today explains, it is a vision that in some respects is in peril. If you're in a law school today, a lot of the action centers around originalism and textualism, and things that are regarded as non-originalism has been sent to the wings. Originalism and textualism occupy center stage in American legal education. Justice Breyer has many significant moves in this book. If you're at all interested in law or interpretation, your library is incomplete without this book. I learned immensely from it, and one of the important moves that he makes is that he says, I am a traditionalist. I am a traditionalist. And he claims the mantle of Chief Justice John Marshall, among others, who has a more pragmatic, workable approach. So the book enters an intellectual debate about the nature of legal interpretation. And for some of you, that might sound woefully abstract, but I can assure you that the consequences of that debate are profound and tangible. And that's what this book is really all about. Okay, Justice Breyer, would you like a quick rebuttal, or should I just dive right into my questions?
He was a great law clerk, and we had very interesting cases. And Yale is benefiting at the moment, absolutely.
Okay, thank you, thank you.
And thank you for inviting me, and thank you for coming to this lecture. And how many of you are in law school or lawyers or want to go there? All right, not too many. So shall I tell them in a sentence what we do in a court of appeals?
Please do so.
All right. This is a stupid joke, but it's actually, while being a very stupid joke, and at the same time, it tells you what we do. You tell me if I'm wrong. I read in a French newspaper, so I want you to see it. French, it says, a biology professor is going from Nantes to Paris, and he has in a basket 20 live snails. So the conductor comes up, looks at it, and says, have you got a ticket for the snails? He says, what? This is crazy. What do you mean buy a ticket for the snails? He says, well, read the fare book. The fare book says, no animals on the train unless they are in a basket, and you pay a half-price ticket. What are they talking about? Dogs or cats or rabbits? They're not talking about snails. He said, is a snail an animal? Huh. Now, I tell that to the 7th grade. The 7th grade, they're looking out the window. You got to get them back. But as soon as they hear that, I say, what do you think? I don't have to say another word. I do not have to say another word. They say, half of them, well, no, that's ridiculous. You mean you have to buy a ticket for a caterpillar? Or a mosquito or something? You know, is a caterpillar an animal or isn't it? Okay, I say, now you understand what we do in a court of appeals with the Supreme Court. Now you understand it. It may be that the words are different. It may be it's not animal. Maybe the word is the freedom of speech. Or right to bear arms, same idea. What does it mean? Where does it apply? What's the scope of that? What does it apply to? And it's not easy, nor for that matter is the snails. But it's hard because we only take cases in the Supreme Court where lower courts, well, I exaggerate a little, but basically, where the lower courts have come to different conclusions on the same question of federal law. All right, now you understand the whole thing. Anyone want to leave there needs to resist. Okay.
Okay, I never thought I'd say this, but let's stick with the snails for a little bit longer. And your book has generated a lot of attention, including a review in the Harvard Law Review by an esteemed federal judge. And he takes you up on your snails hypothetical. And he sort of suggests that you would be skeptical of the idea of buying a train ticket for snails, and that it would be more about a dog or things of that nature. He says, from his view, if all animals must have a ticket, then he has to buy 20 tickets for those snails as well. I'm curious what you make of that argument.
No, he may have the money to do it. I personally, I don't think so. Because I'd say, what's the point of this? And the point of the snail example is I don't know the point. I didn't look further into it. I noticed the next day the railroad company gave the guy his money back. And so I couldn't tell you the answer to that one. I'm probably better on freedom of speech, but there are those who think I am not better. But nonetheless.
Okay, so I'm curious if you could back up and tell us about why you felt compelled to write this book at this particular moment. It is no easy thing to write a book. It's an especially difficult thing to write a book if you are a Supreme Court justice. Judge Posner reviewed one of your books in 2006 in a favorable review in the Yale Law Journal, and here's what he said. A Supreme Court justice writing a book about constitutional law is like a dog walking on his hind legs. The wonder is not that it is done well, but that it is done at all. Does that job become easier if you are a retired justice rather than an active justice in your ability to communicate? So
Yes.
Why this book now?
Yes, it does. Because you've had, I wrote this book with lots of examples that I'd said, and they were over. And really, to be honest, I picked examples because I knew law professors all over the country probably know the theory of these different things far better than I. Or at least, yes, that's true. And, but I've had some experience they haven't had. And therefore, I wanted to write it from my experience. I wanted to write it out of the cases that I've seen. And I wanted to say why it is that I think the words very often do not tell you the answer. I mean, I know if the word is vegetable, that doesn't mean, say, a fish. I understand that. But that doesn't very often give you the answer to the case. So look back. Someone wrote those words. Why? Why? Let's find out. They used to say, one of my clerks became a professor of legal history and said in the 18th century they asked, what is the mischief that the legislature is after, trying to stop when they wrote those words? Or let's look at the purposes. Or let's look at the consequences. If there are terrible consequences, that's a good reason for staying away. This document has a lot of the values that we hold important, this Constitution, in the United States of America. And sometimes looking at them directly will help. And the object of law, I was taught when I was in law school at Professor Hart and Sachs and Fuller, and they said, law, it's an institution. It isn't all people do. It is one of the things that people do in societies. And the object of their doing so is they hope that by having systems of law, we, 330 million now, we started out at 4 million, we've grown, but we will be able to get on because we have every race, every religion, every point of view possible in this country. My mother used to say that. She used to say, well, we lived in San Francisco, so you'll understand. But she used to say, there's no view so crazy that there isn't someone in this country who doesn't hold it. And then she usually added, and they all live in Los Angeles. But nonetheless, Can we stay together? A good question now. Used to be trite, but now it isn't. And can law help us live together peaceably and productively so that we are richer, peaceful, and we live together with people who really don't agree with us? We can do it. And law helps. That was their point of view. That stuck in my mind. I said, why go further? Mm-hmm.
Would you tell us some of the problems that you find with originalism as a mode of constitutional interpretation?
Yeah, the difference, textualism is you're usually with statutes, they'll call it textualism. With the Constitution, they'll call it originalism. But a case, here's a case, a textual case. Many of you, probably most of you, know that if unfortunately you have a child with a handicap of some kind, the school must, under the law, public school, must create special programs to help them. And if you don't like what the school is doing and you think it could be done better, you can bring a law case. And if you win that law case, the statute says you are entitled to cost. So the case in front of us, the woman did win. And she said, I'm entitled to cost. I would like the cost of my educational expert. That was $29,000. So does that word cost, does that mean include the educational expert? Or is it just the lawyer? Or maybe it isn't the lawyer. Maybe it's just the filing fee. What is it? So I'd say this to Nino Scalia, who was a good friend, but he did not often, or too often, think the same way I did. And I'd say, oh, I see, it's textualism. I should read the word. Okay, I'll read the word. You know what the word is? Cost. Oh, I see. You have to really read it. Look at it really hard. Okay, I'll really read it. Cost. Okay, got it. Now, oh, you mean read it several times? Cost, cost, cost. I'll tell you what, you know what? Big thing. It doesn't help. Okay? And there are a lot of cases that I think are like that. And so, and the textualists will go to other things too. But they will they do what they call them semantic things. Semantic things. This is a great word because nobody knows what it means. But it means something to do with language. And I say language isn't the whole story. Purposes help. Values help. Consequences help. The history of this particular bill. And when you get to originalism, see, a lot of the words in this document are pretty abstract. So Nino says, don't look at purposes, don't look at consequences, just look at what the ordinary person would have thought this meant, the people who took part in the political process at the time it was written. That's what we should look at. And now that's why the only good thing, there was a case which some of you know, probably many of you, called Dobbs. And Dobbs was about abortion. And I dissented in Dobbs. All right. So I thought Dobbs was sort of interesting for a number of reasons. And one of the reasons is we'll have to go back a step. Because what the textualists and the originalists will say is they say, we're going to promise you something. And I think this is why they're popular. One, it's easy. Two, you'll get the same results everywhere across the country. Three, the Congress will like it because they know what will happen to their statute. And four, you will not be able, and your friends, to substitute what you think is good for what the law requires. Okay, as to the first three, I can go on all night, which I won't. But with examples like the cost example. It's not so easy. You won't get the same result everywhere. Congress won't even pay attention to you anyway. And beside that, now, Dobbs gives me a chance on number four, because I don't think I try to substitute what is good for the law. I think every one of the 9 of us tries to get it right on the law. Yeah, okay. But now, let me ask you a question, Mr. Originalist. You said you're going to see what people thought at the time they wrote it. Well, Dobbs was an abortion case. It was the same thing with the gun case, the Second Amendment. I said, okay, you're going to overturn those cases? Wait, how are you going to do the Second Amendment? Do you know what they meant in 1789? They said, well, the briefs tell us. Oh, the briefs tell you. Really? One brief says one thing, one brief says another. I've been reading a book at that time. It was Clarence Thomas who was writing it, and he's a good friend. He's a good friend. I like him, and we get on well. And I said, okay, I see. The book I was reading called The 100 Years' War. I'm not going to exactly recommend it because it's 5 volumes, and it is written by a judge who retired in England. And you learn a lot. It's called The 500 Years' War, Minute by Minute, or it's 100 Years' War. That was it. But in any case, I learned some things in that. So I asked him, well, what about a skill ladder? Is that something that is the predecessor of the bazooka? Well, I know perfectly well. He doesn't know. I don't know. It was in the index of the book. So I said, and what about Asian fire? Asian fire, they used to throw it over the wall of the city to burn it up. I say, is that the analogy? Is that the founder of the artillery? No, he doesn't know. I don't know. We don't know history very well. So you want to go just by history? We go just by the people who were there in 1868 or 1870 when we're deciding the abortion case because they wrote equal protection of the law. Oh, we go by what the political people were, all the people who were part of the political, wait a minute. When you say, we ask what the ordinary person thought at that time the words meant, you mean the people who took part in the political yeah. I said, weren't there some people missing at that time? Weren't there a few? Give you a hint. One of the groups missing begins with a W and it ends with an N, and they're 5 letters, okay? Another were the recently freed slaves. Did they count? They might have had a different idea about whether abortion was there or not. I see. So how do we choose? How do we choose what those words meant back then and only back then? And you say, I can, with my more complicated system of interpretation, I run a risk of substituting what I think is good or bad for the law. Okay, I have a question to ask you, Mr. Textualist. Which cases are you going to overrule? Which ones? Are you ready to overrule every case that didn't use textualism or originalism? Are they candidates for being overruled? And you know what his answer is going to be to that. Can you see what his answer is going to be? How many think yes? How many think no? Yeah, it has to be no. Why does it have to be no? It has to be no because too many cases. This textualism didn't start till recently. I mean, are we going to overrule every case? Or are they all candidates? Even if they're all candidates, you, the client, some of these people here are clients. They go to the lawyer, and the lawyer says, you can't do that, it's against the law. And if you can overrule every case, the client will say, let's get it overruled. And there will be chaos. Chaos. So he's not going to say every case. Okay, so I'll say, well, what cases are candidates? And probably he'll say, the ones that are, do you know the 2 words they used in Dobbs? What was wrong with Roe v. Wade? You remember those 2 words? Did any of you read them or read them in the press? He said, the writer, that was Alito actually, he said that Dobbs was activism. He could have said that. I can see that you have been reading detective stories in the evening. And said, yes. Like egregiously? Yes, those are the words. Egregiously wrong. Oh, I see. You are only going to overrule those that are egregiously wrong. And how do you know which are egregiously wrong? Egregiously wrong in whose opinion? Ah, in your opinion. And doesn't that sound a little familiar? Doesn't it sound a little familiar? Isn't there a risk in that you might substitute what you think is good or bad for the law? You see, so I don't think, you see, remember 4 promises? No, not going to work, at least that's my opinion. It just won't work. And so let's go back to what I learned in law school, Holmes and Cardoza and Brandeis and John Marshall and so forth. That's what I call traditional. Why not be traditional?
Okay, let me ask you this, Justice. A skeptic would say, although I'm quite persuaded by your account,
Well, he was my law clerk, so he had to be.
a skeptic would say that the difficulty with pragmatism, workability, traditionalism is that it provides too much discretion to the judge. And so I'm curious if you would offer, if there is an example of your methodology sort of inhibiting you and constraining you from reaching a particular outcome that you wish were on the table. I have in mind here your colleague, now Justice Gorsuch. When he was nominated, then Judge Gorsuch said, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law commands." So what would you say to your colleague?
We used to discuss that at the court, and I would say, I decide the things I like. I never like the things I decide. Much more than you think. I can give you an example. We worked pretty hard on writing an opinion about the death penalty. And the point of that opinion, which took about 2 years to write, was that you can have one of two things. You can have a legal system that looks carefully and fairly into whether this defendant actually committed murder, for example. Or you can have a legal system that will have a death penalty. But you cannot do both. They are mutually, and that's what I tried to explain why, that they were mutually exclusive. So you might guess from that I'm not one of the key supporters of the death penalty. I thought it's not a good thing in the law. I didn't say overrule it. I said let's consider overruling it. Now, I have sat on and heard and voted on many, many cases because I lost that case. I did not have a majority when I wrote those about the death penalty. So that wasn't the law. And in many, many, many cases, where we get quite a few, of death cases, I would vote for not taking the case, for the death penalty, because I didn't have a majority. So I had to vote, and it was the right thing, in my opinion, to vote for the death penalty in those cases. And there are plenty of others.
Okay. Which of your dissents do you most wish were written for a majority of the court? So if you could pick one case.
The one case I tried to stay calm, and I do stay calm. I might tell a joke occasionally, but it's usually quite a bad joke. But I try to stay calm. And in that conference room, see, we get about 8,000, 7,000 requests to hear cases. We probably hear about 70 in the year, 60, 70 cases. When we hear a case, they write, both sides, their briefs. They write a blue brief, that means the judge was wrong below. Red brief, no, he was right. Yellow brief, reply. Oh, I read the yellow brief first because it says the same thing, but it's shorter. Okay, but then light green, we're on the blue side. Dark green, we're on the red side. Gray, the government. The government's always gray. I don't know why. But nonetheless, I read the briefs. I ask Justin, or whoever is clerking for me, I want you, I tell them what I'm thinking initially, and they will write a memo, but they don't have to stick to what I'm thinking. They will write what they find. And there will be some questions in there, some legal issues, I don't know the answer. And then we will we will in fact discuss it. I like to discuss it with all four clerks. I love that. You get some different views, and that's what I need. And then we're in oral argument, and that's for the judges. We think it's for us to ask questions, not for the lawyers to tell us their best argument or worse. They can, but look, if they had a new point, why didn't they make it in their briefs? So we ask questions. And the best kind of question, in my opinion, is you ask a question that was not answered, it's still in your mind, the lawyer probably knows more about it than I do, and I can learn something that might help me with this case. And Clarence Thomas, for a long time, he's now talking much more, but he might have thought that was the null set. Or you might ask a question to show your colleagues where you're coming from, sort of on this. Or you might try to make it funny. Don't do that. You can see how tempted I am. But don't do it. You do that, and the lawyer it seems to favor will go, ha, 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 ha. See, and the other lawyer will look furious. Don't do it. But then 1 or 2 days after that oral argument, we're in the conference, a room about the middle of this size, and we're sitting around the table alone, and we go around in order of seniority. And we each have a black book for each case with the names of the other judges, and the chief begins, and he says, this case is about da-da-da, and he takes about 5 minutes or maybe 10, and says, I'm leaning here, and this is why. And then it would go to Clarence, and then it would go to me, and then Alito, and then Sotomayor, and Kagan, and Gorsuch, and Kavanaugh, and who do I think? Gorsuch and Kavanaugh, Amy Coney Barrett, Justice Jackson, who was at one time my law clerk. And she was a very good law clerk, too. Thank you. She's there recently, you see. I was never served with her. Well, in any case, we go around. Nobody speaks twice till everybody speaks once. And and you go back and forth. Very good rule for any small group. And by the way, when you start to speak, the worst kind of thing to say is, well, I have a better argument than you, ha, ha, ha. You don't have to say it with those words. All you have to do is let the other person imply that's what you're saying. If that's what he thinks you're saying, forget it. You're going to convince nobody. Because the person on the other side will think, no, I have a better argument than you, ha, ha, ha. And that will get us nowhere. The secret to that conference, listen. Listen to what the other people are saying. And see if you can work with that. And you can't always, sometimes you can. And then you get somewhere. So, nobody speaks twice till everybody speaks once. You listen to what is being said, sometimes get somewhere. I have never heard a voice in that conference raised. Never. I have never heard a judge in that conference insult, or not even as a joke, another justice in that room. I've not heard it. It's professional. You're thinking through very difficult cases. And it's not something where it's very serious. You come away with a possible view. You think you know where people stand, and then you write opinions. You'll write a draft or a memo. If it's assigned to me, it's assigned 1 and then 2 and then 3. But if it's assigned to me, and then I read that, I sit at the word processor because I was a teacher before, and I change the first word. No professor can change the first word without then changing the second word. And then it gets to the third word, and there you are. And pretty soon it's not quite the same, and I give it back to him. He thinks he wrote a better one, but he's very polite. He'll say, well, all right. And then you go back and forth till you get something to circulate. You circulate it. The others will read it, and what you want is a memo from them with 2 words. I join. Usually you get something more than that. And they'll say, I join if. And then you have to decide how far will you go, and so forth and so on. And eventually everybody, they can write a dissent. Everybody's written dissent, or they've rejoined, or they've written the concurrence, or they've joined one of the others, and we're ready to get it out, and it comes out. Now you know the whole procedure, and that's what it is for virtually every case. Okay? And I think it works fairly well.
Thank you, Justice. And tell us about one dissent that you particularly regret. And, you know, I was with you in October term
the one
2006.
that you worked on. That is the one I particularly regret. And I did. I'll explain about it. Because, yeah.
Should I tell people what that case was about, or do you want to tell them what it was about, Justice?
You can tell them, but suppose what he says is different from what I think.
Well, the case was called Parents Involved in Community Schools. And it was really a case about the legacy of Brown versus Board of Education. And could school districts take affirmative steps to bring about racial integration? And Justice Breyer felt strongly about that case, wrote a long dissent. And maybe you could tell people why you felt so strongly about that particular case, Justice.
I felt strongly about it because I thought the 9 people on the court are not necessarily the great experts on whether we're going to bring the country together without affirmative action. If I'm honest about it, I have to say I don't know. But I do think that the Constitution, I did think, and I do think, I left the court, I do think that the Constitution, when it says equal protection of the law, gives people leeway to experiment, to come up with the way to achieve its great objective, which was to take people at that time who were former slaves or perhaps related to, and to bring them into the country. And bringing them into the country so that we have a population that is a population made up of all different races and religions and so forth. That's quite different from invidious discrimination, the object of which is to keep them out, you see. And I did feel that strongly. And perhaps I felt that pretty strongly because this is my father's watch, and my father was the attorney for the school board in San Francisco for 40 years. So that's how I grew up, part of the school system. And you're writing about it. There was hardly any education law when he started off. And it grew, and Justin's writing about it. But I can't say I did behave my best during that case, because you can once or twice or 3 times during the year give a brief summary of what you've written, dissent, if you have. You can do that maybe once or twice or 3 times a year. And so I sat there while they were announcing it. Should I tell them this? I guess so. All right. I sat there, and Chief Justice Roberts, who was a friend, a good friend, he said, the way to stop discriminating is to stop discriminating. But what crossed my mind was, well, if we're going to decide this on the basis of bumper stickers, I can think of a few too. So I said, well, I sort of worked in, I spoke for 22 minutes, and I know that because Nino was timing it, and he got a little into it. And I said, rarely in the law have so few so quickly changed so much. That was not exactly a compliment. And maybe I wouldn't do that again. I would do it again on that, on that case. But don't do that too often. And no, that's the story.
It was a really important statement at the time. Justice Breyer said it is not often in the law that so few have so quickly changed so much. This was said at the end of the first full term that Justice Alito and Chief Justice Roberts were together on the court, and I actually have a poster in my office now of that very phrase that was reproduced by a cartoonist. It is not often in the law that so few have so quickly changed so much.
But sometimes this is Holmes, and Posner thinks this is the only thing you can contribute, a phrase. And a phrase will sometimes matter.
Yes.
But don't spend your time doing it, because very few people can do it. And when Nino and I would go around and talk to audiences, students usually, we often get the question, why do you say so many insulting things about your colleagues? Now I know that's meant for him, and it was, but I would answer it. And I would say, I know you mean that for my colleague. Justice Scalia, but I'm going to answer it. And the answer is this, that some people suffer from a disease. And the disease is called good writer's disease. And he is a good writer. And when a good writer finds a phrase, a felicitous phrase, he cannot give it up. He can't give it up any more than a good comedian can give up a good joke. And if you're a good comedian and you know a good joke, your life could be at stake. You can't give it up. You're going to ruin yourself, but you can't give it up. And I said, that's what he is with felicitous phrases, with good phrases. And we all know that. And we don't take it seriously. And that was true. And that was true. But you,
Justice, let me ask you about one of your excellent lines that you wrote as a justice, and it's in the majority. People often say that the really excellent writing happens in dissents, but yours is from a majority opinion. I think this may be the single best sentence you wrote as a Supreme Court justice, and I'm curious if you could tell me about the origins of it. It was in a case involving a high school student called Brandy Levy. This is known as the curious case of the vulgar cheerleader. And she cursed on a Snapchat off campus. And Justice Breyer wrote the majority opinion. But here's the one I want to direct your attention to, and if you could tell us about the origins of it, if at all. America's public schools are the nurseries of democracy.
look, I have my father's watch. So what? This is why this is an unusually difficult case, and I'll tell you why. And you'll see how complicated they can get. In particular, the writing of it can get very complicated. All right, what she did, her coach had promised her she could be on the first cheerleading team, and then he didn't let her on the first cheerleading team. And she was in a rage. So she went to her favorite, pumpkin latte favored coffee shop, and she texted her 322 best friends, and she said, if you don't mind my vulgar language, what she said was, fuck the coach, all right?
Fuck cheer. Fuck cheer.
Oh, all right, that's what she said. Yes. Okay. So the coach found out, and they decided to punish her. But her family, her mother, I think, was a little on her side, and brought a case. And then it got to us. It got to us, and it's not such an easy case. Can the school punish her for something that she said outside of school? And we thought, maybe sometimes, maybe they're on a trip, or maybe they're on, some kind of, but not here. She was in her own coffee shop, they thought, in the coffee shop, and she did just for friends, and people in the school wouldn't have gotten it, and she wasn't bullying anybody, and she wasn't threatening anybody, and therefore she did have a First Amendment right to say that. That was the holding. And I'm writing the case for the court. But I think, now, if I write it just like that, the schools are going to think, because you have a big audience, the schools are going to think they can't punish the students for anything they say outside of class. That's wrong. I don't believe that. I can think of many situations. They threaten the teachers. They get a gang. They threaten a student. They act badly on a school trip. I mean, I can think of many situations. So I don't want to say that. So I say it, but then I say, of course, the rules of free speech for a grammar school or a high school are different than, say, for a college or for adults. And then I worry about that. As I say, now they're going to think maybe they can punish anybody for anything. I don't want that either. So what we ended up doing was writing the phrase you said. So it says, yes, you have to let her go. You have to let her go. You can't punish her. She didn't hurt anybody. But remember, schools are different. Younger students are different. But does that mean you can't punish any? It doesn't mean that either. So I find this phrase. And you see what I want to do with that phrase. Schools are the nurseries of democracy. Is to get the school teachers to think about it. I want them to think. I want them to read that First Amendment. I want them to see that that First Amendment, at least in part, is a road This is in a good book. It's in a book called Archie Cox told me to read. The Law and Its Compass by an English judge, Lord Denning. It wasn't Denning, it was Radcliffe. He said, read that first part. Oh, Bert Newborn, good book. The First Amendment and its music, the music of the First Amendment. What? First, Congress shall make no law on religion. Religion at that time was mostly political, but political thought would mostly take a religious form, or a lot of it. If you start with the idea at the beginning that it's thought, you can think what you want. And where does it go next? Speech. You say? Speech. You think what you want, and then if you want to, you can say it. Mm-hmm. Many would be well advised not to say it. But you can't control that. If you want to say it, say it. Abridging the freedom of speech? No. Or the press. And if you really want, and you say something pretty good, and you say it after having thought it, you can spread it around. Mm-hmm. The press. And then, by the way, after the press is assembly. And assembly, well, if the press gets it around and people want to talk about it, they can assemble and talk about it. Some can be for it, some can be against it, some can have other ideas, and out of that assembly or a discussion of what perhaps the press has spread around, of perhaps what you have said after having thought it, we begin to have a public opinion formed. And that public opinion, for, against, in the middle, you see, and it ends up communicating with Congress. You see? And that is pretty much one of the ways in which a democracy works in a big country. Start with thought, speech, spread it around, form a public opinion through discussion, and get it over to Congress. So they don't have to, but they can react. They'll know what the public thinks. All right? I'd love the schools to teach that. I'd love them to teach that. But I can't get all into all that in an opinion, so I just say, remember, the nurseries of democracy are public schools. That's what they were, and that's what I think they should be. But where did I get it? Should I tell you the truth?
Please.
The wedding service of the District of Columbia. If you are not married and you want to get married and you want to have a lovely wedding service and you're not going to have a religious service, go get the one that they wrote in the District of Columbia. It's great. And they have a line in there that I copied. It didn't say schools, but it said marriage is the nursery of heaven. I've always liked that when I've had to marry some of my clerks. I like that. There we are. Okay, there you have the whole story. I don't know you wanted the whole story, but you have the whole story.
We've broken news today. I don't think you've ever told that story before, so thank you for sharing that. Now, it's not so very long ago that you were an undergraduate at Stanford contemplating a career in public service. There are a lot of people who fall into that category out here. What advice do you have for them? What do you wish that you had known as an undergraduate as you prepared to embark on your decade-long career of public service?
I was told the best thing about your decisions that you're going to have to make. What do I do with my life, career? Whom do I marry? Huh? They're not decisions that are so easy or so obvious. But Bayless Manning, who was the dean of Stanford Law School at a relevant time, said, I'll tell you something. You are never going to know when you make those decisions more than 2% of what you really ought to know to make a sensible decision. And there's no way to know more than 2%. So, lighten up. Relax. You will make them, and then your life will unfold itself around them. Of course, I thought my dad and my family would not have moved outside of San Francisco for anything. They loved it. And they wouldn't have moved to Atherton, which had a lot of very expensive houses, or even Marin County. And my father liked the school system. It was interesting. It was interesting and worthwhile. There are many, many And that's what I usually, many careers, I say to the students when I'm talking to them, I hope at least you will participate in this community. This being the community you're in. Participate. That's important. And Derek Bloch said it much more toughly in a book he wrote. He said, he quoted Pericles, and I don't know if it's a correct quote or not, but regardless. Pericles, when he gave that famous speech in Athens, one of the lines, supposedly, was, what is it we say in Athens about the man who does not participate in public life? We do not say he is a man who minds his own business. We say he is a man who has no business here. Mm-hmm.
Thank you, Justice. Last question from me, and then I want to get to a couple of audience questions with our limited time remaining. You have many wonderful qualities. One of them is that you are an optimist of epic proportions. That's one of your reputations as being a world's great optimist, and I saw it up close, and I've benefited from it. Many young people today are not feeling optimistic, to put it mildly. What would you say to today's young people and a few not so young people about why they should nevertheless retain some sense of optimism?
I can only say, well, I have a little bit less after last week, but nonetheless, nonetheless, I still probably lean on the optimistic side. I worked for Senator Kennedy for a few years, which I loved. It was a great job. And he would say to his staff, don't go after this for credit. Forget about the credit. Just forget about getting credit. If you succeed in what you're trying to do, and it's good, there will be credit for everybody. And if not, who wants the credit? But then I would tell, if I'm talking, we're back in the 7th grade, okay, or 8th grade maybe, or high school, or whatever it is, I'm talking to those students there at the window, and I say, no, I'd like to tell you one thing that Kennedy did tell his staff that was yet more important, I thought. He said, when you run into a situation where you find some opposition, you can't get your bill through, or you can't stop the bill that you want to stop, or whatever it is, when you're in this situation of difficulty, the first thing you do, and John Stuart Mill, I think, said something like this, you find a person who you believe honestly is intelligent and thinks the opposite of what you think. And you go to that person and you talk to them. No, don't talk too much. Listen. Listen to what they say. And to tell you the truth, more often than not, they will end up saying something that you really agree with. And as soon as they say something that you really agree with, you say, what a good idea you have. Mm-hmm. And then if you achieve something and you get together on something, 30%, that's good enough. Take the 30%. Don't hold out for 100% so all your normal followers will say what a hero you are. You are not a hero, you got nothing. Get the 30%. All right? And I heard him many times. The press would ask him, they'd say, Senator Kennedy, you did such a good job on this. And he'd say, don't thank me, thank Orrin Hatch, the Republican, who came up with the idea that brought us together. Now, I've suddenly, when I've said just what I told you, I've suddenly don't see these students at the window. They've left the window. They're interested. They're interested, they're listening to what I'm saying. That happens not always, but quite a lot of the time. And it isn't what I just said, but it's their interest. It's the look in their eye when they hear me tell them what Senator Kennedy told me. Okay? And it's that look in their eye that tells me maybe they are interested in helping keep this country together. Maybe they are interested in listening to other people. Maybe they are interested in at least having something to do and some advice. And it's that look, it's that interest that makes me, on balance, optimistic.
Wonderful. We have time for a question or two from the audience that have been submitted. The first question comes from Malcolm Furman, class of 27. He says, you've long supported a pragmatic approach to constitutional interpretation that considers real-world outcomes and consequences. But pragmatism also means living with the results. Has there ever been a moment where, looking back, you felt that a decision that you supported had unintended consequences or simply didn't produce the outcome that you hoped for?
Yes. But I think when it's too technical when it came to, but I won't say who, but it was Nina who convinced me to join about an opinion about witnesses and what evidence you can bring in, and I thought this was going to be great and really help. And I'd read some law professor's article on it, and I thought, yeah, this is good, and then it turned out I didn't like it so much. Okay, and there are probably others, but Sandra O'Connor told me 2 unwritten rules. One unwritten rule is no one speaks twice till everybody speaks once, and the second is tomorrow is another day. And you and I might have been the greatest of allies on case 1, but case 2, which doesn't have to do with case 1, we're totally at odds, okay? And so it tends to make you forget the past. You're on to the next one. Arthur Goldberg told me that. Arthur Goldberg said, when I was a law clerk, yeah, I'd come in, I'd be sorry we didn't get 5 people on an opinion that we'd worked on. So he would say, well, am I supposed to cry about that or what? He'd say, no, what we do is it's on to the next one. It's on to the next one. Mm-hmm.
Last question. We have a couple of minutes remaining here. This is from Professor Scarbeck. You've written extensively about the importance of public trust in the court. After Bush versus Gore, Dobbs, and the Dobbs leak, and growing polarization, what gives you the most hope that the next generation will still believe in the rule of law? Very easy question to end on here, Justice. The rule of law.
The rule of law is, it's not of interest, it's just what I told my friend who was Chief Justice of Ghana. The rule of law means nothing when you've got the case decided the way you like. It means something when you are willing to go along with cases that are important. You didn't like them. And maybe you were right, and the judge was wrong. After all, it's a 5-4 case. Somebody's wrong. And that's when you see whether the country has the rule of law. And what is it? My favorite quote on the rule of law? It's a good book, too. It's not about law. It's a great book. It's Albert Camus, The Plague. A lot of us read that during the COVID. And it's the story of Oran. And it's a pretend plague because it's really about the Nazis in Germany, I think, during World War II. And at the end of the book, he says, why did I write this book? He says, I want to show you how people acted, some well, some badly. And he said, I wanted to tell you about the role of a doctor who's a hero. A hero. Without a theory. No philosophy or theory, you just help. When you have a chance to help, you help. That's the doctor. You don't need a theory. You do it. And also because the pest, the plague germ, the bacillus de la peste, the plague germ, it never dies. It goes into remission. It goes into remission and it lurks. It lurks in the attics. It lurks in the hallways. It lurks in the file cabinets. And one day, to the misfortune or the education of mankind, it will reemerge. And it will once again send its rats into a once happy city. And the reason I like that is I say, the rule of law, in my opinion, I have self-interest in this, the judge. The rule of law, in my opinion, is one, not the only one, but it's one of the weapons that human beings have created in order to keep that rat in its hole so it cannot reemerge, so the chances are less. And so we who are involved in law, use it. Use what you know about the rule of law so that even though a lot of decisions that I've lived through I haven't agreed with, so, it's a big country, And the object is to help them, try to get them to live together peacefully and productively. And the rule of law is one of the weapons we have, which we hope will help.
Thank you, Justice, for a wonderful set of comments. Thank you.
I want to do a couple of things. I want to thank, of course, Justice Stephen Breyer, and thank, of course, Professor Justin Driver, Brown alum, for an outstanding, just fascinating conversation. As a teacher, you always measure whether there's coughing in the room or anything, and we were just rapt for that hour. So thank you so much. And I also want to point out that this is also a kickoff event for the Brown 2026 effort, initiative. It's a very big deal. We have Professor McLaughlin, Professor Karen Wolf here in the audience, and there are going to be just tremendous amounts of programming and wonderful talks and opportunities for students to learn all about the history of this country for the next year. So we want to congratulate them on this kickoff event, and thank you for their co-sponsorship. And thank you so much for coming. And we will have an opportunity to purchase books and get the books signed right outside. So I think we're going to let Professor Driver and Justice Breyer go out first, and then we'll exit the room. So thank you so much for coming.